Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every day at 8 a.m. Eastern Standard Time. Please like, subscribe, and click the notification bell if you like our content so you can be updated every time we upload new content. Let's move on to question number 1. Drew was tried for the July 21st murder of Victor. Drew called Wilson to testify to alibi. On cross-examination of Wilson, the prosecution asked, "Isn't it a fact that you are Drew's first cousin?" The question is A, proper because it goes to bias, B, proper because a relative is not competent to give reputation testimony, C, improper because the question goes beyond the scope of direct examination, or D, improper because the evidence being sought is irrelevant. Take 10 seconds. Choose the best answer now. I hope you're off to a good start and chose A, proper, because it goes to bias. Let's look at the other options here. B, proper because a relative is not competent to give reputation evidence. There's no such rule that says that they can't. So as a result, B would automatically be excluded. C, improper because the question goes beyond the scope of direct examination. We have no idea what the direct examination of this witness here was, so there's no way that we can tell that this is within or without the scope of that direct examination. So as a result, C must be excluded. And finally, D, improper because the evidence being sought is irrelevant. That would be a question for the judge hearing the case, not a general question here. Secondarily, if we're mentioning there's alibi evidence, how could alibi evidence be irrelevant? If there's a murder charged and an individual testifies that the defendant was actually, in fact, somewhere across the globe, not anywhere near where the crime occurred, how could such testimony be irrelevant? As such, D must be eliminated as a possible option, and we're left only with A, proper because it goes to bias, and that is, in fact, accurate. The question, in essence, is asking whether there is some potential for bias given the fact that they're close relatives. Question number 2. Ben was the illegitimate, unacknowledged child of Fred. Fred died intestate, leaving neither spouse nor any children other than Ben. The state's laws of intestate succession provides that an unacknowledged illegitimate child may not inherit his father's property. The spouse, all other blood relations, and the state are preferred as heirs over the unacknowledged illegitimate child. Ben filed suit in an appropriate court alleging that the state statute barring an illegitimate child from sharing in a parent's estate is invalid, and the state's strongest defense of the statute would be that A, the authority of a state over the disposition of decedent's property located in that state is not affected by the Constitution of the United States. B, a statute prescribing the means of disposing of the property of intestate decedents does not constitute invidious discrimination. C, inheritance under intestate succession laws is a privilege, not a right, and therefore is not protected as property under the Due Process Clause. And D, its interest in promoting family life and its encouraging the formal acknowledgement of paternity gives the law a rational basis. Take 10 seconds and choose the best answer now. If you chose option D, great work. Its interest in promoting family life and in encouraging the formal acknowledgement of paternity gives the law a rational basis. The Due Process Clause of the Fifth Amendment applies equal protection to the federal government, and the Equal Protection Clause of the 14th Amendment applies equal protection to the states. Equal protection is invoked when a law treats one person or class of persons differently than others. Equal protection provides that all citizens must be offered the equal protection of the laws. Legitimacy classifications are subject to intermediate scrutiny, meaning the law must be substantially related to an important government interest. Intermediate scrutiny is more rigorous than rational basis review, which only requires that the law be rationally related to a legitimate government interest. Here, the state's law of intestate succession discriminates against children conceived out of wedlock, because an unacknowledged illegitimate child such as Ben, is not allowed to inherit his father's property. Under this law, the spouse, all others, blood relations, and the state itself are all preferred as heirs over an unacknowledged illegitimate child. Legitimacy classifications, such as the state's law of intestate succession, are subject to intermediate scrutiny. The only answer option with the closest reasoning for the statute being substantially related to an important government interest is D. Note that although the reasoning in D may not be sufficient to pass intermediate scrutiny, it is still the best defense among the answer options. As such, the state's best defense among the answer options is that its interest in promoting family life and in encouraging the formal acknowledgement of paternity gives the law a rational basis. Question number 3. The Pinners, a retired couple, have lived in their home in a residential neighborhood for 20 years when the Darleys moved into the house next door and built a swimming pool in the backyard. The 4 young Darley children frequently played in the pool after school. They often were joined by other neighborhood children. The Pinners were in the habit of reading and listening to classical music in the afternoons. Sometimes they took naps. The boisterous sounds of the children playing in the pool disturbed the Pinners' customary enjoyment of quiet afternoons. In the Pinners' nuisance action for damages against the Darleys, the Pinners should A. prevail if the children's noise constituted a substantial interference with the Pinners' use and enjoyment of their home. B. prevail because the Pinners' interest in the quiet enjoyment of their home takes precedence in time over the Darleys' interests. C. not prevail unless the noise constituted a substantial and unreasonable disturbance to persons of normal sensibilities. Or D. not prevail because the children's interest in healthy play has priority over the Pinners' interest in peace and quiet. Take 10 seconds and choose the best answer now. I hope you chose answer C, not prevail unless the noise constituted a substantial and unreasonable disturbance to persons of normal sensibilities. A private nuisance is an unreasonable interference with the plaintiff's use and enjoyment of their own land. The interference must be substantial. In this case, the boisterous sounds of the children playing in the Darleys' pool will be an unreasonable and substantial interference with the Pinners' use and enjoyment of their home if the sounds are offensive, inconvenient, or annoying to the average person. Thus, the Pinners should not prevail unless the noise constituted a substantial and unreasonable disturbance to persons of normal sensibilities. Question number 4. Alan, who was already married, went through a marriage ceremony with Betty and committed bigamy. Carl, his friend who did not know of Alan's previous marriage, had encouraged Alan to marry Betty and was best man at the ceremony. If Carl was charged with being an accessory to bigamy, he should be found A. not guilty because his encouragement and assistance was not the legal cause of the crime. B. not guilty because he did not have the mental state required for aiding and abetting. C. guilty because he encouraged Alan and his mistake as to the existence of a prior marriage is not a defense to a charge of bigamy. Or D. guilty because he was present when the crime occurred and is thus a principal in the second degree. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct, not guilty, because he did not have the mental state required for aiding and abetting. If one aids, abets, or facilitates the commission of a crime with the intent that that crime be committed, one can be found guilty under the theory of accomplice liability. Note that accomplice liability is not a separate offense, but rather an alternative way to be found guilty of the primary offense. Here, Carl did not know Alan was already married when he encouraged Alan to marry Betty. Since Carl did not know of Alan's previous marriage, Carl could not have been or had the intent for Alan to commit bigamy. Therefore, Carl should be found not guilty of being an accessory to bigamy because he did not have the mental state required for aiding and abetting. Question number 5. Drew was tried for the July 21st murder of Victor. Drew called Warren to testify to alibi. On cross-examination of Warren, the prosecutor asked, "Weren't you on the jury that acquitted Drew of another criminal charge?" The best reason for sustaining an objection to this question is that A. the question goes beyond the scope of direct examination. B. the probative value of the answer would be outweighed by its tendency to mislead. C. the question is leading. D. prior jury service in a case involving a party renders the witness incompetent. Take 10 seconds. If you chose B, you'd be correct. The probative value of the answer would be outweighed by the tendency to mislead. Evidence is legally relevant if its probative value outweighs unfair prejudice. Under the federal rules of evidence, the credibility of a witness may be attacked by any party, including the party who called him. The credibility of a witness is always at issue. Impeachment by evidence of bias, interest, or motive can be entered through cross-examination or extrinsic evidence. In this case, the prosecutor was attempting to impeach Warren's credibility on cross-examination by asking about Warren's prior service on a jury that acquitted Drew of another criminal charge. The prosecutor was implying that Warren's alibi for Drew could not be trusted. However, the probative value of this question is small and its tendency to mislead is great. Serving on a jury that acquitted a defendant does not mean that the jury member is biased in favor of that defendant. It also does not mean that there is any motive to lie about the defendant's whereabouts in the current case. All the prosecutor's question does is alert the jury to Drew's prior criminal trial, which is clearly prejudicial. As such, the best reason for sustaining an objection to this question in this case is that the probative value of the answer would be outweighed by the tendency to mislead the jury. Question number 6. Alice conveyed Twin Oaks Farm to Barbara, her heirs, and assigns, so long as the premises are used for residential and farm purposes, then to Charles and his heirs and assigns. The jurisdiction in which Twin Oaks Farms is located has adopted the common law rule against perpetuities, unmodified by statute. As a consequence of the conveyance, Alice's interest in Twin Oaks Farms is A. nothing, B. a possibility of reverter, C. a right of entry for conditions broken, or D. a reversion in fee simple absolute. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct. A possibility of reverter. The rule against perpetuities states that for a future interest to be valid, the interest must vest, if at all, within 20 years after some life in being at the instrument's effective date. The rule against perpetuities does not apply to indefeasibly vested remainders. Vested remainders subject to complete defeasance or future interest regained by the grantor. The possibility of reverter accompanies a fee simple determinable, a fee simple that it automatically comes to an end when a stated event occurs or fails to occur. In this case, Alice conveyed Twin Oaks Farm to Barbara, her heirs, and assigns, so long as the premises are used for residential and farm purposes, then to Charles and his heirs and assigns. This shifting executory interest in Charles violates the rule against perpetuities because it is possible that the land is used for something other than residential and farm purposes well after Barbara's life plus 21 years. As such, it would be stricken from the conveyance, so the conveyance would now read, to Barbara, her heirs, and assigns, so long as the premises are used for residential and farm purposes. As such, Barbara and her heirs have a fee simple determinable, and Alice keeps a possibility of reverter because it is possible that Twin Oaks would revert back to Alice should Barbara cease using the property for residential purposes. Question number 7. Darlene was arrested on a murder charge. She was given Miranda warnings and refused to talk further with the police. At trial, she testified in her own defense. She recounted in some detail her whereabouts on the day of the crime and explained why she could not have committed the crime. On cross-examination and over defense objection, the prosecution emphasized the fact that she did not tell the police the story following her arrest. The prosecution thereby suggested that her testimony was false. Defendant was convicted. On appeal, she claims error in the prosecutor's cross-examination. Her conviction will most probably be A. affirmed because defendant's silence at time of arrest is tantamount to a prior inconsistent statement, giving rise to an inference that the story was fabricated. B. affirmed because defendant's silence was not used as direct evidence, but only for impeachment, a purpose consistent with legitimate cross-examination. C. reversed because post-arrest silence constituted defendant's exercise of her Miranda rights and use of that silence against her at trial violated due process. Or D. Reversed because to require the defense to acquaint the prosecution with defendant's testimony prior to trial would constitute unconstitutional pretrial discovery. Take 10 seconds and choose what you believe to be the best answer now. If you chose option C, you'd be correct. Reversed because post-arrest silence constituted defendant's exercise of her Miranda rights, and use of the silence against her at trial violated due process. The silence before Miranda warnings are administered is admissible to impeach defendant if the silence is inconsistent with the defendant's testimony at trial. Post-Miranda silence, however, is inadmissible. In this case, Darlene refused to talk with police after she was given Miranda warnings. The prosecutor is not allowed to use her silence after Miranda warnings to impeach her testimony. As such, her conviction will most probably be reversed because post-arrest silence constituted defendant's exercise of her Miranda rights, and use of that silence against her at trial violated due process. Question number 8. Redirect examination of a witness must be permitted in which of the following circumstances? A. To reply to any matter raised in cross-examination. B. Only to reply to significant new matter raised in cross-examination. C. Only to reiterate the essential elements of the case. Or D. Only to supply significant information inadvertently omitted on direct examination. Take 10 seconds and choose what you believe to be the best answer now. If you chose option B, you'd be correct. Only to reply to significant new matter raised in cross-examination. Rule 611 of the Federal Rules of Evidence states that a court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to 1. Make those procedures effective for determining the truth, 2. Avoid wasting time, and 3. Protect witnesses from harassment or undue embarrassment. Here we see that the question stem is asking when redirect must be permitted. This is an indication that the answer for this question will be limited in scope. While redirect is generally at the reasonable discretion of the judge, when a significant new matter is raised in cross-examination of a witness, then redirect of that witness to address the significant new matter must be permitted. Question number 9. Longacre was conveyed to Celeste and Donald by a deed which, in the jurisdiction in which Longacre is situated, created a co-tenancy in equal shares and with the right of survivorship. The jurisdiction has no statute directly applicable to any of the problems posed. Celeste, by deed, conveyed my undivided one-half interest in Longacre to Paul. Celeste has since died in an appropriate action between Paul and Donald, in which title to Longacre is at issue. Donald will, A, prevail because he is the sole owner of Longacre. B, prevail if, but only if, the co-tenancy created in Celeste and Donald was a tenancy by the entirety. C, not prevail if he had knowledge of the conveyance prior to Celeste's death. Or D, not prevail because Paul and Donald own Longacre as tenants in common. Take 10 seconds. Choose the best option now. If you chose option B, prevail if, but only if, the co-tenancy created in Celeste and Donald was a tenancy by the entirety. Option B, you'd be correct. The rule is that a joint tenant may sell or transfer her interest in a joint tenancy during her lifetime without the knowledge or consent of the other joint tenant. An inter vivos conveyance will sever the joint tenancy as to the conveying joint tenant's interests, and the buyer is a tenant in common. A tenancy by the entirety, on the other hand, cannot be severed by a unilateral conveyance by one spouse. In this case, Longacre was conveyed to Celeste and Donald with a deed, which created a co-tenancy in equal shares with the right of survivorship. Celeste, however, unilaterally conveyed her one-half interest in Longacre to Paul. If this co-tenancy is a joint tenancy, this unilateral conveyance by Celeste would sever the joint tenancy, and Paul and Donald would hold Longacre as tenants in common. However, if Celeste and Donald are husband and wife, and the co-tenancy created was a tenancy by the entirety, Celeste's unilateral conveyance cannot sever the tenancy by the entirety. As such, in an action between Paul and Donald, Donald would prevail, but only if the co-tenancy created in Celeste and Donald was a tenancy by the entirety. Question number 10. Lender met borrower on the street, demanded that borrower pay a debt owed to lender, and threatened to punch borrower in the nose. A fight ensued between them. Man came upon the scene just as lender was about to kick borrower in the head. Noting that lender was getting the better of the fight, man pointed a gun at lender and said, "Stop or I'll shoot." If lender asserts a claim against man based on assault, will lender prevail? A, yes, because man threatened to use deadly force. B, yes, unless man was related to borrower. C, no, if it was apparent that lender was about to inflict serious bodily harm upon borrower. Or D, no, because lender was the original aggressor by threatening borrower with battery. Take 10 seconds. Choose the best answer. If you chose option C, you'd be correct. No, if it was apparent that lender was about to inflict serious bodily harm upon borrower. A person is entitled to use reasonable force to prevent any threatened, harmful, or offensive contact. A victim may use deadly force in self-defense if the victim is not at fault, the victim is confronted with unlawful force, and the victim reasonably believes that she is facing imminent threat of death or serious bodily harm. A defendant who comes to the aid of another person may assert self-defense of others if the defendant honestly and reasonably believed that the other person had the right to use force in their own defense. The defender is permitted to use the same degree of force that would have been permitted if the tort was threatened against the defendant, as if the defender steps into the shoes of the actual victim. In this case, man came upon the fight just as lender was about to kick borrower in the head. At that point in the fight, borrower was likely justified in using deadly force in self-defense because the facts don't indicate borrower was at fault and borrower was about to receive a serious bodily injury. Man stepped into the shoes of borrower and used the threat of deadly force with a gun to prevent the head kick because it seems apparent that lender was about to inflict serious bodily harm upon borrower. Man's self-defense of borrower was reasonable and force, thus lender would not prevail in an assault claim against man. As always, thank you for joining us in Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell if you'd like to see more content like this, and if you want to be updated every time we upload new content.